Hey folks, Eric here, the whatever guy, because it really is whatever for me. Do you folks want to know about this judge allowing these depositions and stuff to go forward? You guys stick around, man, and we'll talk about that. As you guys know, my name is Eric. I am the whatever guy, and I shoot videos a couple days a week, basically keeping you guys updated in the world Delta 8, Delta 9, Delta 10, hemp, cannabis, just what's going on around. And today, man, sitting here bullshitting around on an early Thursday morning. I actually shot another video. That video is actually loading up to YouTube right now. I will probably have to make that video private. I actually shaved since then. So tomorrow when you guys see the video, you guys will see an unshaved guys, because I actually shot that video earlier this morning. It was about THC caps, a bill that was passed through in Florida with the Senate committee, and we're going to talk about that tomorrow, like I said. But today, man, we got some news on the judge actually granting the plaintiffs in the Alabama medical cannabis debacle we've got going on here in the state of Alabama. And as I've said many times before, man, this is crazy. This is a crazy situation, and they violated the Open Meetings Act many times. And now it pushes through. They were asking for 6 depositions. I think they're going to get 5, and they're going to get a lot of discovery on what's going on, and they're going to be allowed to depose those 5 commissioners for up to 7 hours. That's a crazy situation. That's a long time to sit for a deposition, and that's a long time for them to ask a lot of questions. So we're going to get to the root of a lot of what's going on in the system. And so we're going to flip over here to an article over at, I believe this is over at the Alabama Reporter. We're going to check it out and see what they say. And this is by Jacob Holmes, by the way. And it says, a court allows discovery to move forward in a medical cannabis suit. Let's skip on down here. It says Montgomery County Circuit Court is moving forward with limited discovery in a lawsuit against the Alabama medical cannabis cartel. Mike Jackson, attorney for the AMCC, told Judge James Anderson he came prepared to argue against discovery altogether, but chose not to make that argument in apparent deference to the court. Bullshit. Anderson is limiting plaintiffs to 6 depositions of AMCC Director John McMillan and 5 commission members. AMCC attorneys attempted to limit those depositions to just 4 each, but Anderson granted the federal standard of 7 hours to depose subjects. The bulk of the hearing Wednesday was spent with about a dozen different attorneys weighing in on the AMCC's claim that certain questions should be off limits because the commission has deliberative privilege. Anderson ultimately decided that the depositions could move forward and did not block plaintiffs' counsel from asking specific questions, but said AMCC attorneys can assert their privilege during depositions. Those assertions could then be reviewed by Anderson on a case-by-case basis. That's how it should be done, Will Somerville, counsel for Alabama, always said following the hearing Wednesday. The numerous attorneys representing many different companies in the commission did their best to sway Anderson as to whether that privilege actually applies to a governing body such as the AMCC. Plaintiffs pointed to the Alabama Open Meetings Act, which specifically states that the deliberative process is to be public. AMCC counsel argued that the meetings are public record, but that an individual commissioner's mental process for determining how they rank companies goes too far. Plaintiffs argue they need to be able to ask commissioners why they made decisions to discover whether those decisions were arbitrary and capricious, violating rules under the Alabama Administrative Procedure Act. They told Anderson they could demonstrate that the rankings are ultimately arbitrary. Ben Epsey, attorney for Bragg County, argued that the ranking of a single commission member dragged the company's average score down enough to place a company 7th on the list. The commission only made it to the 6th applicant on the list before it had awarded its statutory limit of 5 licenses, leaving Bragg County without a chance at a license. Espy pointed out that Harvey ranked Sustainable Alabama 29th, but when it came time to vote, voted in favor of awarding the company a license. Crazy, right? If you put me at 29, that means I'm in the bottom 5. How can you vote yes with somebody who's in your bottom 5 unless your ranking is completely arbitrary? And that's exactly what it is. But Jackson told Anderson the ranking was only determined in what order to consider the licenses. They continue to harp on that and try to convince Your Honor that the rankings are what the awards were based on. As Espy explained how Harvey's rating dragged down Bragg County's score, Jackson remarked, so what? Plaintiffs told Anderson that remark amounts to an admission that the ranking process was arbitrary. The MCC also continued to a line of argument that this is the improper time to allow discovery, as a procedure gives opportunity for relief within an investigative hearing. Plaintiffs, however, argue that they need discovery before any investigative hearing, or they will have nothing to argue before the administrative law judge that they deserve the license over another applicant. It's unclear exactly when the depositions will be completed. Plaintiffs are seeking documents that were before commissioners before conducting depositions. But Anderson said he still intends to move forward with the next scheduled hearing on February 28th. Guys, This is crazy, and I'm glad we're getting some depositions in this case. I'm not sure how how this is going to affect the timeline as far as maybe the AMC appeals it up to a higher court. They have done that before. They've actually threatened to do that. But I already told you long before this that the talks had broken down, and they were going to have to get in front of Judge Anderson to decide what depositions he was going to allow. So apparently they're going to allow 5 depositions of commissioners and 1 of John McMillan. So that's 6 total. That'd be 7 hours apiece, about 42 hours worth of depositions that we're going to have. And I'm assuming that the judge is going to be sitting there during these depositions because he's going to be able to argue or have to make decisions on what questions can be asked during that period of time. So that's a lot of work between now and then, guys. Like that's 7 hours of basically sitting. So that's 1 day each. For commissioners to go through, and that's hopefully they don't have any time limits throughout the day other than lunch. That will put them in an 8-hour day. This is going to bring those guys out the woods. They're going to have to come out the woods, stop the hunting, and actually deal with this situation right here. And maybe we can get an understanding of why you would rank someone 29, but then vote yes to give them a license because you ranked them in the bottom 5. Like you didn't think when you ranked them on the score that they were good enough to get a license, but you voted yes on the other side of it. Like we want to know what was going on in your head when you voted yes to these applicants right here. And I would imagine before the end of this is done, we will probably do an opinion article that's actually over at Alabama Reporter right now, and that basically is talking about pushing this off to the legislature and allowing the legislature to take care of it. But let me just say this: the rumors that I'm hearing is that the legislature doesn't even want to deal with this. They would rather just scrap the whole program altogether. So I don't know if that's true or not, but that puts us in a dire situation on the other side too. All right, folks, whatever guy signing off, and I will talk to you guys later, man. Love it. See ya.